call the shoebox defense. Well, I got all the stuff in a shoebox. I didn't really keep the records. They open themselves up then to, because they can't prove they paid, and the claim by the employee, if he's got records and he kept his date book, is going to prevail. So the records need to be kept for the employer as well as the employee. So just my comment. And like I said, there's a variety of different ways people commit these wage thefts. And I've seen most of them. They're difficult to prove. But if we can have a deterrent along these lines, and I think you're on the right track about willful or at least knowingly is a little bit lower standard, but high enough still. You know, a lot of these things are chasing a rabbit down the rabbit hole. The requirement to keep the records are in the law already, and people need to follow the law.
Thank you. With that, we're going to go ahead and move to support of AB 211. If those in Las Vegas and Carson City, if you guys like to come to the table, fill up the 4 chairs here if there's that many individuals. Can you raise your hand in Las Vegas if you're going to testify in support? I just want to make sure. 1, 2 people. Okay. All right. Ms. Mancini, I'll let you go first. Welcome.
For the record, Sherry Mancini, President, Service Employee International Union, Nevada. Chair Bustamante Adams, committee members, thank you for this opportunity to provide testimony on this reprehensible issue. I speak today in support of AB 211 and on behalf of the home care workers that we represent out of SEIU who make $10 an hour on average and are among the most frequent victims of wage theft, likely because the agencies that employ them can get away with it. Home care workers provide the valuable care that allow the elderly and disabled to remain in their homes. They are mostly women, minorities, and immigrants. They rely on every dollar they earn and are reluctant to speak up in fear of retaliation. A 2009 report found nearly 93% of home care workers reported overtime violations, 90% say that they worked before or after shifts without getting paid, and nearly 1 in 5 reported minimum wage violations. They are exploited by agencies and deprived of their rightful wages. When one woman who works for a home health agency spoke up and had the audacity to ask to be paid fairly, her employer responded, "You're illegal and you're asking me for more money?" One owner of 2 Las Vegas home care agencies deprives workers of overtime by splitting their hours between her 2 companies, thus avoiding the 40-hour threshold. Public monies pay for 83% of home care. When workers are cheated, taxpayers are cheated too, and the employer fraudulently pockets the profits. Home care workers are isolated and the industry lacks oversight. All of these factors create an atmosphere where wage theft can thrive. And while trouble damages would normally be a disincentive to greedy employers, home care agencies must also be regulated and required to abide by federal labor standards. It's in the public interest to ensure home care workers are valued and protected. With an aging population and high turnover in this rapidly growing industry, our failure to respect and pay home care workers will put our loved ones and ourselves at risk. We believe AB 211 will be a step in the right direction and will make bad actors think twice before they deny their employees their rightful and hard-earned wages. And I also would like to say, in response to Assemblyman Hansen, when good employers make a mistake, the employees go to them and they correct their mistakes. They don't have to continue to go on to court. Normally, when you don't get paid properly, you go to your boss and say, "Hey, I have a problem with my paycheck." And the people who know they made a mistake, they pay you. It's the people who are blatantly, the companies that are blatantly, knowingly taking rightful wages away from hardworking individuals that are the problem. And they need to have some stiffer penalties to make them think twice about whether they want to take that action or not. Thank you.
Thank you, Ms. Mancini. We'll take the young lady in purple up in Las Vegas.
Chairwoman Bustamante Adams, members of the committee, thanks for the opportunity to speak today. My name is Deetra Pasby. Unfortunately, I am all too familiar with the topic of your hearing. As a home care worker employed by 2 agencies which share common ownership, I have been denied my rightful wages for more than 4 years, despite the Obama administration's new federal labor standards. I generally work 46 hours a week. However, I am paid 23 hours regular time from one agency and 23 hours of regular time from the other agency. My employer requires this arrangement to avoid paying me overtime. I am telling you my story despite the fear that I may lose my job. I am telling you my story because, like other home care workers, I work hard and earn little. Each of us deserves to be paid fairly for the valuable services we provide. Thank you for your time, and I encourage you to protect all low-wage workers from wage theft.
Thank you for your testimony. I appreciate it. Mr. Halsey?
Good afternoon, Chairwoman Bustamante Adams, James Halsey, IBW Local 357. Wage theft and underpayment of wages is a problem in Nevada and has been for some time. In recognition of that problem, our union and our contractors together hired a wage compliance officer in 2002. Over the past 15 years, this compliance officer has assisted in returning to over 343 underpaid electricians. And I'll give you that in perspective right here. I added up all that amount of all the electricians that had lost money, and it was a total of $1,062,160.19. They were all deprived of wages between the years of 2002 to 2015. Some of these cases involve lower dollar amounts can be chalked up to administrative errors, and for many of the contractors, it's just plain wage theft. Let me give you an example. In 2010, on Fire Station 22, a Clark County project, an electrical contractor built a new fire station to replace an existing one. This was a prevailing wage job with signs clearly posted on site which specified it was a prevailing wage project. In this case, the contractor misclassified their workers as laborers as opposed to electricians. In addition to the misclassification, they only compensated their workers for 16 hours a week when they were in reality working for 40 hours a week. As a result of this kind of wage theft, we have contractors who bid and compensate workers fairly, the county and the workers all losing out. The contractor in question had a history of incorrectly paying their employees on prevailing wage projects. This project, Fire Station 22, started in 2010. A wage claim was filed in May of 2011 on behalf of 16 electricians. A wage determination by Clark County for over $400,000 was issued on March of 2012. It was appealed by the contractor and finally settled for $175,000 in the fall of 2012. In the end, only half the workers received any money. In closing, there needs to be more incentive for a contractor or company to pay a worker correctly. It is apparent from what we have experienced, the current law does not encourage compliance. Thank you.
Thank you, Mr. Halsey. Is there anybody else here in support of AB 211? Seeing none, we'll transition to those in opposition. That means that you don't like the bill as is. There's something that's either a concern or you would like to change a wording or insert something differently, and be specific what it is that you want to change. That would help us keep an accurate record and help the bill sponsor as well. So is there one person in Las Vegas? Is there in opposition? Can you raise your hand? Okay, just one. We're going to go ahead and take you in Las Vegas first. If you just state your name for the record.
Thank you. Yes, thank you, Chairwoman Bustamante. My name is Lorraine Marshall and committee members, and I oppose AB 211. I am a small business owner, and treble damages will encourage employees or former employees to sue, even if they're lying. Things such as sick leave and PTO can be disputed, and it can take a small business owner a lot of time to prove their innocence. As an example, once when I was out of town, I had a former employee bring a false claim against my business. I worked to get an extension for my response to the state while I was out of town and spent hours when I returned to my office to pull documentation together to prove my innocence. In the end, my business was found innocent, but what does this bill do to address people who lie to get money from a small business? Are there any deterrents being considered which would discourage rather than encourage these types of lawsuits, especially when the individual is not telling the truth? Many people say that they are friends of the small business, but bills such as this certainly don't show it. I believe most politicians don't understand the amount of time, energy, and effort that it takes to prove yourself innocent. They think it takes 5 minutes to pull up some paperwork, but that's never the case. Sometimes you have to consult with an attorney or other HR experts to prove your innocence. By allowing former employees to get triple damages, you're encouraging a lot of this because there's no downside for them. They just want to try and make as much money as they can any way they can. Thank you.
Thank you, Ms. Marshall. And if you can just spell your last name for the record for our secretaries, that would help.
Marshall.
Thank you so much. And then we'll take Mr. Abney. I think this is your first time in Commerce this month, right?
I sat down at this end of the table for a reason, but sure, I can go first. It is my first time, Madam Chair. Good to see you. For the record, Trey Abney, representing the 1,500 members of the Chamber of Reno Sparks and Northern Nevada. I want to apologize to the sponsor. I was able to reach out to her by email, but haven't had time to sit down and chat with her yet with this bill. It sounds like with some amendment language, our position could change depending on what that language says. Obviously, we're concerned about willfully, and if employers are making a good faith effort to move forward on these things, we want to make sure that state government is helping small businesses become stronger, and we're always concerned about anything that's punitive or that transfers money from small businesses to lawyers. And so, again, having not seen the amendment, can't comment on that, so we're opposed as the language is written here in front of us, but certainly want to work with the sponsor on this, and I appreciate your time. Thank you, Madam Chair.
Thank you so much. Next.
Bob Ostrowski, for the record, today representing the Nevada Resort Association. I signed in opposition because, we weren't satisfied with the language as a whole, but members of my staff have been working with the bill sponsor. We believe, from the testimony that we heard today, that the targets here are bad actors, intentional violators, people that operate in bad faith generally. We don't have any disagreement with that, nor do we have any disagreement with the concept of allowing the injured party to get treble damages. We believe, though, the way the bill is drafted, it applies to all sections of 608, which is everything from break time to lunchtime to overtime to minimum wage. We believe that it's appropriate that the bill be narrowed in focus to 608-190, which in fact talks about intentional acts on the behalf of an employer. And with an amendment doing that, the Resort Association is prepared to support this bill if it's well defined as an intentional act. We believe 608-190 does that. If it's inadequate, we're willing to look at it and work on that language to try to get it there. And just from my perspective as a former senior HR executive, both for MGM and for Bally's, having hotels and manufacturing under me, and whether you're a big employer or small, there's no defense like a written record. So to the extent we would have the presidents of our hotels sign a timesheet every week, they hated it. But I would tell you that in the long run, having a timesheet, having it signed, indicating break times, painful for small employers, but it is the best insurance policy you can buy, because I've heard testimony about, perhaps folks being wrongly accused. You got a paper record, that's how you defend yourself. So we can support the bill with the appropriate changes. We will continue to work with the bill sponsor, who's been very cooperative in dealing with us. I think we're all after the same thing. We believe the language doesn't get us there, but there is language that will. Thank you.
Thank you so much. Next.
Thank you, Madam Chair. For the record, Gary Milliken, representing the Nevada Contractors Association. I'm in agreement with Mr. Ostrowski's comments. I've met with him. I've met with the bill sponsor. And anything, just adding the word willful, I thought Assemblyman Anderson made a good comment about good faith effort, but we look forward to working with the sponsor and getting the language. Thank you.
Thank you. Last.
Good afternoon, members of the committee. Paul Moratkin with Las Vegas Metro Chamber of Commerce. The Chamber is opposed to the current form. We have had conversations with the bill sponsor, and she is receptive and open to the dialogue we're having regarding the broadness of the current drafting of this regarding to this particular chapter. And we, of course, will look at the amendment once it's available to see if that does address our overall concerns with the bill. As has been reiterated, our concern is we want to ensure that we are protecting those good actors in this, and of course, those that are not. The Chamber, of course, understands the intent of this bill regarding those bad actors. So we do look forward to the additional dialogue with the bill sponsor and the upcoming amendment. Thank you very much.
Thank you, Ms. Moratkin. A question from Mr. Hanson and then from Ms. Carlton.
Thanks, Madam Chair. Actually, not any of them could probably address it. Two things. One, if even if you got a good paper record, but you're challenged and you are exonerated, do you normally in these types of hearings get any kind of payback for your legal costs and time?
This Bob Strauss from the record. Just my experience through the chairman to Mr. Hanson is that it is very rare in Nevada for any case ever to make it to a courtroom. Most matters are resolved administratively with the insurance commissioner's office. And there's time and energy, hopefully no legal bills, but there may be. And no, an employer, as you know, if they want to defend themselves, they do it on their own dime. I really can't speak to what would happen in a case involving a judge in a district court. I'm not sure what the award rules are.
Well, the answer then pretty much is no, as you know, because this may open up a whole new avenue of going to court. The other question I've got, now you guys are obviously representing some pretty darn big employers. MGM, for example, has 50,000 employees, so obviously you're going to have top-notch people making sure all your payroll. But for the smaller companies, I've got a lot of questions in my mind as to how this whole thing could work out. The other question I have on this whole thing is class action lawsuits, okay? It's one thing to have a small number of employees doing this, but if you have, for example, the IBEW representative just said that in his time frame they had $1.1 million in back wages that they got through whatever the legal venue that they used. That means that somebody now could be on the hook for $3.3 million. So I can see where this opens up a big can of worms for class action lawsuits, especially on big, huge projects involving unions, because the upside potential for this is enormous if they can show that the medium-sized contractors and smaller contractors in particular on prevailing wage projects that may not keep their records quite as well as MGM and the giant casinos do could really, really suffer under this thing. So I got some real concerns over the automatic 3-time type of thing. So I'm just wondering if you had any experiences with class action type lawsuits involving these wage disputes?
Again, this is Bob Ostrowski for the record, to the chairwoman, to Assemblyman Hanson. No, I haven't had any experience with the class action lawsuit. I think the testimony from Las Vegas indicated that most of those dollars were actually settled with the employer at the time. If someone works out of classification for 2 hours during the day, do they get 2 hours of the upgraded pay, or do they get upgraded pay for the entire day? Those are the kinds of payroll errors that are made on a fairly, I don't want to call them regular basis, but I mean, in a big company, every payday, there's always people at the paymaster saying, I was a cook that day, not a cook's helper, because they upgraded me for the day. And mistakes are made and they're fixed. Class action is always a word that makes most employers kind of shudder. They're usually big dollars. I mean, frankly, from my perspective, if I'm a lawyer and someone comes to me and says, my boss owes me $27 in overtime, you're going to say, gee, I'm sorry to hear that, but no one's going to pursue a $27 claim. That's just a fact. But someone brings, a $27,000 claim, that's another matter, more likely to be pursued.
Right, or $1.1 million. Thank you, Madam Chair.
Thank you. Ms. Carlton?
Thank you. And on the mistakes are made, we've all been down that road, but unfortunately, the employee has to wait another 2 weeks to get their pay. They don't cut it right then. They have to wait till the next pay period to get it, but we won't go down that road. Mr. Ostrowski, on the wages, you said limiting this just to wages would make folks more comfortable. Did I hear you correctly?
For the record again, Bob Ostrowski, no, actually, I think it should be all money is owed, no matter what it's from. I said the way it's written, it covers everything, and my real thrust is it should be intentional, not an error. But if they're owed money for a lunch break missed, or if there's a meal payment due, they should fall under the same provision if it's an intentional act.
So what wouldn't be included then in your mind?
For the record again, Bob Ostrowski, nothing that could be turned in, nothing that could be monetized. If they're due money, they're due money.
Okay, I guess I'm trying to figure out what's trying to be eliminated then, because you said you wanted it to focus on just that one section.
Yeah, well, here, for the record, Bob Ostrowski, my problem is the way it's drafted now. It talks about any forum. It actually talks about an action or proceeding. I view that as going to the labor commissioner as an action. Labor commissioner writes a letter. I think these should be intentional acts, which are found in 190, which require some legal action to be taken. I heard over and over again in a testimony about courts making decisions. That's fine, and there ought to be treble damages. My problem is I never had a case where someone went to the labor commissioner and the labor commissioner didn't call or send a letter and say, this employee is due X overtime, prove otherwise. I paid it, and I didn't wait 2 weeks. When I was in charge of HR, I told the paymaster, you got it in 24 hours. But that was me when I was in running those operations. It may be different today, but so I don't think we have a difference of opinion. It just what triggers the treble damages is the whole issue, I suppose.
Okay, and I guess I was confused because it sounded to me like you wanted to include some things but not others. So paid sick leave is still included? Break times would be included?
Bob Ostrowski, for the record, any of those things that are spelled out in 608 as required under the Nevada Labor Code.
Okay, thank you.
Thank you. Speaker Frierson?
Thank you, Madam Chair. I mean, I think that I had the same line of questioning, but my reading of 608 already specifically sets forth the requirement that the behavior be willful, a willful failure. So I don't think this bill proposes to take that out. It just seems to me it's already there. And if you have a process where someone is determined to have willfully failed to pay, those are the folks that we're talking about. And so I get my question is for you and Mr. Abney and Mr. Muradkin, who indicated that they echoed your sentiments. If it's clarified that we're talking about the confines of the statute, I think you indicated that that would satisfy the NRA to the extent that there would be support. And I want to make sure that I'm hearing the same thing. I'm recognizing that you haven't seen the language yet. I empathize. I've been on your side before to know you need to see it first. But is that something that you also echo as far as if that's addressed and clear? Because I think the statute, oftentimes when we have a bill draft, it doesn't include the whole chapter, but the chapter has that language in it. Would that be something that then you could then support?
Through the chair, Paul Muradkin, for the record, through the chair to Mr. Speaker, I think the chamber would be absolutely open to that once we see the bill amendment. At this time, our legal counsel did have that concern that the current revision of this bill would actually take away that clarification malfeasance, so that's where the chamber's concern was. But once we see the amendment, we'd be absolutely open to looking at that position again.
Well, and thank you, and I don't want to speak for the bill sponsor, but I do want to point that, I just wanted to put that out there so that we have a fruitful conversation moving forward about whether or not that would encourage support with the existing language in the statute.
Thank you. And I just, for the secretary, during Mr. Ostrowski's response to Mr. Hansen, I believe you said the insurance commissioner, but I think you meant the labor commissioner. Is that correct?
This is Bob Ostrowski for the record. I stand corrected. That is correct.
I just want to make sure. because the labor commissioner raised her eyebrows, and so I wanted to make. Okay, anybody else in opposition then? Mr. Mallory, are you in opposition up in Las Vegas?
I am in the rules of the committee.
Okay, and if you could please go ahead.
Jack Mallory, Assistant Business Manager, Secretary Treasurer of Painters and Allied Trades, District Council 15. In the construction industry, wage theft has what you would consider to be a catch-me-if-you-can policy and scenario. Workers are either unpaid or underpaid their overtime, sometimes paid less than minimum wage. On prevailing wage projects, they're paid less than the prevailing wage. They're underpaid the total number of hours. But if there is a complaint filed with the Labor Commissioner's office, in many cases, that claim is limited just to workers who come forward and file that claim and file that complaint. There are potentially other workers that are involved and injured under that same situation. The reason that I'm in opposition to this bill is because it does not contemplate enveloping those additional workers. If there was a mechanism put in place within this bill where those individuals could be brought into a claim, not necessarily in the scenario of a class action as was referred to earlier by Mr. Hansen, but in the administrative process within the Labor Commissioner's office, where if there was a case that was found to be valid, a more complete investigation be completed by the Labor Commissioner's office to determine whether or not there were more workers harmed. I think that that would satisfy our organization. And an example of this is several years ago, the Clark County School District self-performed repaints on a number of schools. And the case to cite on this is Melendrez v. Clark County School District, where there were two workers who ultimately ended up receiving an award from a claim against the Clark County School District for a violation of prevailing wage. There were dozens of workers that were potentially involved in this case, but only two that were made whole, to the tune of approximately $120,000 in the outcome of the case, where the Clark County School District was found to have violated prevailing wage law. So in our opinion, we feel that that this bill would be a good fit for this type of a provision, and if there were any questions, I'd be happy to answer. Thank you.
Thank you, Mr. Mallory. And just to check, have you spoken with the bill sponsor on your point?
Opportunity to.
Okay, thank you.
I have not.
Thank you so much. Why? And I just want to say for the gentlemen that were at the table, from what I gathered, everybody had approached the bill sponsor, and that's what we like to see in the building, and not to blindside anyone. So I want to thank those individuals for doing that and making sure that we work in a cooperative manner. Next, we'll take these four here in Carson City. Whoever would like to go first.
Thank you, Madam Chair. Members of the committee, Warren Hardy with the Hardy Consulting Group here today representing the Nevada Restaurant Association and the Associated Builders and Contractors of Nevada. First, I want to say how disappointed I am in my fellow business lobbyists who referred to the sponsor of the chair or sponsor of the bill because they were afraid to try to say her name. I told her I was going to take a run at it. I want to thank Assemblywoman Hadighi for taking the time to meet with me on this bill, and I would also associate myself with Mr. Ostrowski's comments, but I do want to express my appreciation to the sponsor. This is one of those bills you sort of read and your hair stands up on end and you run around like your hair's on fire. Then you talk to the sponsor and all of a sudden you say, okay, I see what you're trying to get at. And her intent here is very, very valid and important. From what I understand, it is her intent to find the language. I'm not an attorney. I'm not going to try to play one, but to find a way to make sure that it is willful, but also that it kicks in after there's been a willful failure to pay after a finding. It's pretty difficult to argue against that. So I would associate myself. But I would also point out, to Mr. Hansen's point, Madam Chair, that the devil's always in the details on these things. And so we are very interested in seeing the language
And in anticipation of the speaker's question, I can't imagine when that language is brought forward, and it makes sense in all the respects that I think the sponsor, or Ms. Hadegi, has indicated she wants to have, that our associations won't be in support. Thank you.
Thank you. Perfect pronunciation. Next.
Good afternoon. My name is Leah Tauken with the Retail Association of Nevada. And I don't want to be repetitive, so I will just share the concerns of the other representatives of the business community that have spoke before me, and also suggest that we would like to have the opportunity to reconsider our position when we do see the language of the amendment. Thank you.
Thank you for being concise. Next.
Good afternoon, Madam Chair. For the record, Randy Thompson, representing the National Federation of Independent Business. I'm pretty much just say ditto, especially to Ms. Marshall, who spoke first, the small business owner. There are bad actors and bad on both sides, both bad actors of employees and employers, and I do share her concern that this could encourage employees to go against employers. But again, we'll definitely work with Ms. Howdegi as well and see what we can come up with.
Thank you. Mr. Bacon.
Thank you. For the record, Madam Chair, Ray Bacon, Nevada Manufacturers Association. The only time the manufacturing sector winds up with consistently somebody that's down at the minimum wage level or relatively shortly of that, and this thing has become an issue, is when we go through and change the minimum wage, which we haven't done for a decade. But as we're talking about doing that at this stage of the game, it's not the minimum wage that gets us in trouble with an oversight on the collections. It's when somebody gets into overtime on that new minimum wage, because it's the 1.5 times as to whether it's effective or not. And so consequently, because our state is unique, there's no software that covers that I'm aware of. So some companies have done their own that cover that situation, but a lot of companies are using a standard software package, and so that gets them into an oversight issue, not a willful. So I think this is okay, but it's one of those things that we'll have to watch, because if we change the rules, people are going to be doing something with the 1.5 times issue that they haven't had to do in a long, long time. Thank you.
Thank you so much. I appreciate your testimony. Is there anybody else in opposition of AB 211? Seeing none, we're going to move into neutral. And as a reminder, neutral means that you would be fined if the bill passed as is, but you want to give some information that is relevant to the bill. Okay, seeing none here in Carson City or in Las Vegas, then Ms. Howdegi, would you like to just make some closing comments?
I will. Just a quick note. I'd like to thank you, Chairwoman, and the committee for providing me with the opportunity to present AB 211. And I'd like to thank all of the other organizations who did approach me before. We are working on something that will, again, be a little bit more specific in targeting those who are bad actors that are willfully withholding wages. Again, thank you for your time and your consideration.
I appreciate that. With that, we're going to close the hearing on AB 211. Is Mr. Carrillo in the room? I thought I saw him early. Oh, there you are. Okay, we're going to go ahead and open up the hearing on AB 149.
Thank you, Madam Chair, and Assemblyman Richard Carrillo, for the record, representing Assembly District 18, which covers portions of unincorporated Clark County in East Las Vegas and portions of Henderson. And again, thank you, Madam Chairwoman, and members of the Assembly Committee on Commerce and Labor for allowing me to present AB 149. AB 149 seeks to limit the amount of time that a non-competition agreement can restrict an employee from engaging in certain specified activities after the employment relationship has ended. Essentially, it is to ensure that Nevada workers are able to keep a roof over their heads and food on the table for their families. Nevada workers should not have to worry for months or years about how they're going to support their families. The bill does not attempt to limit other agreements to protect the employer's trade secrets or other legitimate business interests. There are many workers in the state of Nevada who enter into these types of contracts with employers, and the concern is that the longer time periods can cause significant hardship on workers. While it is reasonable to expect that the employer or the employee, not divulge trade secrets, it seems completely unreasonable for an employer to expect an employee to wait from anywhere from 1 to 5 years to become employed in the same industry, or potentially even a similar industry. The Nevada Supreme Court has held that a non-competition covenant is in the restraint of trade and will not be enforced in accordance with its terms unless the non-competition covenant is reasonable. In 2016, the Nevada Supreme Court held that a non-competition covenant is reasonable if the restraint is not greater than is required for the protection of the person for whose benefit the restraint is imposed, and does not impose undue hardship upon the person restricted. In that ruling, the court considered the duration of the restraint imposed upon the employee, the territory in which the employee was restrained from employment, as well as the type of employment which the employee was restrained from pursuing. AB 149 seeks only to address the duration of the restraint imposed and essentially to codify into law the Supreme Court ruling. If, with your permission, Chair, Madam Chair, I would like to take you through the bill. Okay, Section 1 of the bill codifies the standard established by the Nevada Supreme Court to determine whether a non-competition covenant is reasonable. In this section, it also establishes the non-competition covenant is void and unenforceable if the employee is prohibited from competing or working for a competitor for longer than 3 months. Section 2 of the bill provides penalties for an employer who executes a non-competition agreement that violates the provisions of Section 1. And Section 3 provides the provisions of the bill. Section 3 provides that provisions of the bill do not apply to non-competition agreements that are entered into prior to July 1st, 2017, unless modified or amended after that date. Madam Chair, the premise of this bill is to protect the hardworking families of Nevada, and I'm available to take questions. Thank you.
Thank you, Assemblyman Carrillo. Now we'll open up to questions from the committee. Mr. Kramer.
Assemblyman Carrillo, I really like the Section 1 where it says is supported by valuable consideration. In other words, if you go forward and say you can't compete, but they pay them for 3 months or 6 months, then that's valuable consideration. Okay, don't compete because they're getting paid for it. How do you determine, or is it a judicial determination, arbitration determination that valuable consideration has been given, just an agreed upon amount to begin with, or how is that determined? That's my question.
Assemblyman Richard Carrillo, for the record, through you, Chair, to Madam Chair.
Mr. Carrillo, feel free to go directly to the members.
Okay, thank you. Assemblyman Kramer, of course, you know, to give you a final thing, I think we might want to have legal chime in on this to ensure that it's coming from the legal side of it instead of myself.
Go ahead, Mr. King.
Thank you, Madam Chair. For the record, William Keene, Committee Counsel. The amount of the consideration would be, there's no set amount. And I wanted to make clear that, for Mr. Kramer, that it's not that the employer would be paying in advance for that time, that the employee would not be competing. It's built into the compensation that the employee is receiving. For example, in the seminal case of Hanson v. Edwards, even though in the end that non-competition agreement was found to be void, initially what had happened was the employee received an extra 50 cents an hour for agreeing to enter into that non-competition agreement. So if the non-competition agreement had not been found to be unduly burdensome, then the valuable consideration would have been that extra pay while the employee was originally employed. So, and that valuable consideration aspect is actually in existing law in NRS 613.200. Thank you.
And Mr. King, can you also talk about the two cases that were mentioned in the bill, Jones versus Dieter and the Golden Road Motor Inn?
Thank you, Madam Chair. For the record, William Keene, Legal Division. Absolutely. The most recent case, and the one that I think that most people are looking at, is the Golden Road Motor Inn versus Simona Islam. She was a casino host at Atlantis, which is technically known as the Golden Road Motor Inn. And she had an agreement where she would not compete, and she agreed that she would not engage in any employment with a gaming establishment within 150 miles of Atlantis for 1 year. And the court found that to be unreasonable. The other more recent case, Hansen v. Edwards, is the original 1967 case that sort of is the seminal case. The other more recent case is Jones v. Dieter. It's from 1996, and that is where it was about lighting services, and the employer took on an apprentice, and there was a non-compete agreement where the apprentice agreed not to compete by working in that same industry within 100 miles of the Reno-Sparks area for 5 years, and that was also found to be unreasonable. I think the key language, let's see here, the key language was originally written by the court in Hansen in 1967, but it's been repeated by the court since then several times, most recently in Golden Road Motor Inn, which is the key consideration that the court has. The court says, a restraint of trade is unreasonable in the absence of statutory authorization or dominant social or economic justification if it is greater than is required for the protection of the person for whose benefit the restraint is imposed or imposes undue hardship upon the person restricted. That's what the court looks at, which is why, in the end, it's always on a case-by-case basis. What exactly is the duration? What exactly is the geographic limit? What exactly is the limitation on employment? One of the things that the court in Golden Road took issue with was that Simona Islam was not allowed to engage in any employment with a gaming establishment. She happened to be a casino host, but they said she could not serve in any capacity under that agreement, and they found that to be unreasonable. So these agreements need to be looked at on a case-by-case basis. And there is no, at least at this point, there's no judicial limit of time. It's whatever is reasonable. And what this bill is doing is putting a limit on that, saying under statute, more than 3 months would be unreasonable. Thank you.
Thank you, Mr. King. Any other questions for Mr. Carrillo? Speaker Frierson.
Thank you, Madam Chair. I was just curious about the 3 months and where that is that something that we got from somewhere else? Does it exist elsewhere? Just if that number was soft, or if that's already something that we've looked at in other ways.
Thank you, Mr. or Speaker Frierson. For the record, Assemblyman Richard Carrillo, thank you for the question. It was taken from Massachusetts, and they're the ones that had provided the language for basically the premise of Section 1. Basically all of Section 1 was taken from Massachusetts law.
And Mr. Carrillo, did you mention that your constituents brought the concern to you as well? Can you elaborate on that?
Yes, Madam Chair. Richard Carrillo for the record. It was an incident that I shouldn't say incident, but what had happened is they were in the broadcasting industry, and they had closed, or I should say they did away with his job, and he still had to go through the 1 year non-compete where he could not get any type of work in that field. So he was, not say that he was very wealthy, but he did what he could do to ensure that he had his bills paid. But after a year had passed, he was able to get back into the industry. So obviously that did some undue hardship, especially for the fact that you're trying to keep in the same type of trade without having to go work someplace else, or maybe what you did in college while you're going through school to learn your trade. So to me, I felt that was something that, that was the premise of what brought this forth. And, I myself have been, signed a non-compete, and it was even in the air conditioning trade. They didn't want you taking customers from somebody else or from your employer to go someplace else because they decided they're going to pay you more. So I completely understand the need for a non-compete, but without getting too wordy and off course, it was definitely a constituent that had brought this forth to me, and that was why we moved forward with this.
Thank you, Mr. Carrillo. And so from your testimony, I wrote down that the bill seeks to address the duration, and it doesn't limit the agreements to protect like the employer's trade secret. Is that correct? So it's just about the duration, so the employer can still have another agreement to protect its trade secrets or other, you said, legitimate business interests.
For the record, Assemblyman Richard Carrillo. Madam Chair, I think the whole part of it is something that's fluid, and of course every type of trade is going to be different, and of course the trade secrets, because I understand as I've had conversations with individuals that have come to my office, that the concern was is they brought somebody from another place, and maybe they didn't really, maybe it didn't work out, or somebody had said, hey, we can offer you more money. Well, they've already invested into that employee that they hired from another state and brought over, moving expenses and so on and so forth. So I understand that it's kind of a fluid bill when it comes to the time, and that might be something that's, because not every person is, even in the casino industry, not everybody is going to be on that level of CEOs, and you're going to have the lower tiers that may not, of course they'd be on an undue hardship if they were required for 1 year, at minimum, versus the 3-month period. So it might be on a case by case, but same aspect, without, I'm willing to work with the individuals that are concerned about that 3-month, and I know that will be brought up probably. Of course, that was something that was brought up to me earlier, so I'm willing to open to an amendments on it.
Thank you. Ms. Neal, Mr. King, Ms. Neal has a question for you.
Thanks, Madam Chair. So I was looking for clarification on 1C in the bill. When it says undue hardship, you cited to the cases earlier, but what are the factors that would be reviewed for undue hardship, and who exactly is making that decision? Is this between the employer and employee? Is there a middle person? Help me understand that. What have the cases ruled?
Thank you, Madam Chair. Through you to Ms. Neal. This is Will Keene, Legal Division. The court is looking at the undue hardship upon the employee, and it's really very factually based. In each of these cases, they looked at what the employee was doing, what the employee's situation was, and what the agreement was. Is the area in which the person cannot practice, like the distance, 150 miles from Atlantis, is that unreasonable? Is the restriction about what they can do unreasonable? Is it, like you can't do anything that works for any gaming company? Is the duration unreasonable? The original one, the Hans and V. Edwards, it was limitless. It was forever. So those are the things that they look at. Does this agreement end up imposing a hardship on the employee? And that's the court's decision, and they base it just on the facts of the case. It really is just, there isn't any intermediate party. It's the court looking at the facts for that particular employee and saying, does this agreement impose a hardship on this employee that's that's undue, and that's up to the court.
And can I have another quick question? So, and I know you addressed this a little bit, but the valuable consideration in terms of us pretty much changing a contractual term, whenever you have a contract, right, and consideration is not necessarily, we're kind of giving it a value to me. What then does this do in terms of contract law and then having this standard that consideration must be valuable? Because I give $1, right? That's consideration. The thing is, it's in exchange for X. So what's the implication of just having those two words side by side in regards to contract law for the future, I guess?
Certainly. Thank you, Madam Chair. To Ms. Neal, William Keene for the record. Of course, it's important to note that this only applies to agreements going forward, so we would not be changing any existing agreements unless they're renegotiated, in which case they have to be renegotiated with the new terms of this law in mind. As far as what's reasonable, the reasonable consideration or valuable consideration, that's a term that actually was in the pre-existing statute. The statute's in the bill. It's in Section 2. That wasn't from the court, but I'm sure the court, when they look at this, would look at the consideration in terms of what the agreement is. What is the person, the employee, giving up, and what's a reasonable consideration for that, valuable consideration? It could vary. In one of the cases, like I had mentioned, it was 50 cents an hour extra pay. I think that it moved the pay from $6 an hour to $6.50 an hour. So I think that would be on a case-by-case basis as well. Thank you.
Okay, seeing no other questions, then we're going to move into support for AB. Oh, Mr. Hanson.
Thanks, Madam Chair. Actually, my question is for legal again. I'm confused on this then, because it seems to me this is making it, this is now going to criminalize it if the person, in fact, has a clause that is considered unenforceable. It's a gross misdemeanor now, right? So it's criminal law. So I'm just kind of wondering, because I read it, I'm thinking of an insurance company, for example. You and I are insurance business together. I have an insurance company. You have all the details of my entire business, including an email list of all my clients and so forth. We get in a beef. You quit. We have a non-compete clause. I think it's completely reasonable. You move to Fallon instead of living in Sparks, and you open an insurance business, and you immediately use my email list to contact all of my clients, even though we have a non-compete clause, but now you live 60 miles away. I think that's wrong, and so I challenge you in court. If I lose that challenge, or if I try to enforce it, I could be guilty of a gross misdemeanor now?
Thank you, Madam Chair. To Mr. Hanson, Will Keene for the record. Well, the gross misdemeanor is in the current statute.
Well, it's already law.
It's 613-200. But to answer your question, so the way that it works right now is that you're guilty of a gross misdemeanor and you shall be punished by a fine of not more than $5,000. If the current base rule is that that an employer is not supposed to willfully do anything to prevent a person who has left or been discharged from obtaining other employment. That's the basic rule. And then what we have is we have a carve-out from that, which was put in place in 1995. And that carve-out was to allow, was to say that that prohibition that would have resulted in a gross misdemeanor does not apply to you if what you're doing is entering into one of these non-compete agreements. Because on its face, a non-compete agreement is interfering with somebody's ability to gain other employment. And so we have this carve-out for that. And what we're doing now is saying, well, here's a limit on this carve-out. So we're essentially saying this carve-out, which for the most part has already been delineated by the court in its various court cases. Mm-hmm. We're essentially codifying those court provisions and then also adding the 3-month provision. The 3-month provision was not from the court cases. That's something that we're adding. But you've raised a good point, in that, well, how are you supposed to know if your agreement violates the law. If you've entered into a non-compete agreement that will end up being
Well, yeah, that's what
void.
I'm looking for, is as much clarification. What I want to do, obviously I don't want to keep people from being able to make a living, but I also don't want to see where somebody who, for whatever reason, has really sensitive information from a company, who then, for whatever reason, takes off with that information, and then geographically may have, the 50-mile rule or whatever, but then turns around and uses what was proprietary information from my company to compete against me. I think that was one of the reasons you allow non-compete clauses in the law. So what I want to see is, if we're going to do this, that it's really kind of clear as to what is and isn't acceptable under the law. When I read it, it just seems it's quite confusing, frankly, from an employer, employee, contractor kind of a perspective. Maybe you attorneys got it, but it's a little tougher on us blue-collar guys.
Thank you, Madam Chair. To Mr. Hansen, I think the thing that I would note is that the gross misdemeanor for interfering with somebody's ability to gain employment, it already is very fact-based. There's probably things that you could do that would violate that law, and the things that you could do that wouldn't. In some ways, having the 3-month rule makes it a little bit clearer what the time limitation can be, because right now, what an employer has to deal with is just the court cases. The court cases are what we have. And so this bill, if anything, makes the law more clear. But obviously you're right that this bill does not give a safe harbor for number of miles or for exactly what can be involved or exactly what jobs. That is still left to the courts, but the courts are what we have right now without this bill.
Okay. Thanks, Madam Chair.
Thank you. Mr. Kramer.
My question's very similar, except I'm kind of looking at it from a different point of view, I think. If I were a massage therapist or a hairstylist or something like that, and I went to work for some place that had a non-compete, let's say, I'm probably going to bring a lot of my clients with me when I go there. And if later on I open my own station or go into business for myself, do I not get to take at least the clients I brought with me without violating the non-compete? I guess maybe that's in the fine detail, but it seems to me like the 3 months, by the time you go 3 months and don't treat those clients you have, they're going to find someone else. So if you're going to, so I'm just curious about the 3 months as well. Thank you.
Assemblyman Richard Crillo for the record. Assemblyman Kramer, you do bring up a very legitimate point. Of course, as we could, and I'm going to kind of attest to Assemblyman Hansen regarding the trade secrets, because you have a customer list that is not necessarily your customer list, or it could be, as you said, bring it from where you were previously, and you have the following. I mean, I've gone through my hair cutter for the past 6 years. I've been able to track her down, but I made sure I had her cell number, so I was able to keep that. But not a lot of people do that. They just assume, hey, he or she works at that location, and that's where they're going to be. And and then, because I've had that with a previous one where, where's so and so, and it's like, well, she no longer works there. It's like, well, where'd she go to? And they wouldn't tell me, and I was like, great. Now I've lost one that I had for 15 years prior to, and so like I said, I did the smart thing and I got that information right away and I put it on my phone. So I understand your concern about that part of it. And regarding as Assemblyman Hansen had stated, of course, if regarding the actual non-compete itself, if they sign that, hey, we're if you try to take our customers and so on and so forth, then obviously I feel it'd be a legitimate reason to go to court over that, because he's basically, damaging, or he or she may be damaging the business that he or she is leaving. But when it comes down to somebody, as you stated, has a customer list that they're bringing towards, and of course sometimes they say, hey, I can bring the business, and maybe they'll bring their friends as well. So that's something I believe that as it's written in the non-compete, that hey, any customers that I bring are mine, and the other ones that I build up, You know, to me, it would be one of those ones that you, because you have walk-ins all the time for a hair cutter. So they might say, hey, she did a great job or he did a great job. I'm going to go back. But to me, that was somebody that wasn't really their customer or their client prior to their arrival at that location. So I'm not sure if that really answers your question, but to me, that's something that would be written in the whole in the non-compete agreement.
Thank you, Mr. Carrillo. Okay, we're going to go ahead and move to support in AB 149. Is there anybody in Las Vegas? Okay, here in Carson City. Those in opposition, that means there's something about the bill that you would like to change. There's 4 seats. Is there anybody else? I just want to make sure before we move to neutral. Okay, Mr. Muratkin, if you'd like to begin.
Good afternoon, Madam Chair. For the record, Paul Muratkin with Las Vegas Metro Chamber of Commerce. First of all, I think this has been a good dialogue we've had regarding this issue, and we have spoken with the bill sponsor about some of the general concerns the Chamber has regarding this particular bill. As you know, the Chamber is a broad-based organization, and several industry sectors have approached us regarding concerns with this bill, and we do hope to be able to address this with the bill sponsor as we work through these components. But specifically, though, there is some concern from the membership regarding removing some of the flexibility that currently exists with the structure we have in the state by codifying some components of this intent of the business bill. And then also the 3 months, that is a concern, of course, to some industry sectors of the Chamber, but we will, of course, continue to work with the bill sponsor and try and address those concerns. So thank you very much for the time today, Madam Chair.
Thank you. Next.
Thanks. Good to see you again, Madam Chair. For the record, Trey Abney, representing the Chamber of Reno Sparks in Northern Nevada. I'll associate myself with the comments made by my colleague from the Las Vegas Metro Chamber. Sent this out to a few of my folks, and they just have some issues about definitions, about what does valuable consideration mean, and defining that a little more. Thinks that 3 months is a very, very short period of time to put in for something like this. And they also point out that nothing in this bill increases IP or trade secret protections, and if there's something to strengthen that, again, to make sure that an employee doesn't run off with valuable information. And then they also were concerned about merger and acquisition activity, and if this could chill some of that as well. And I'm sure there's others, and I've been communicating with the sponsor and look forward to working with him. He's always great to work with, and so we look forward to that. But thank you for your time.
Thank you. Next.
For the record, Bob Ostrowski, representing Nevada Resort Association. Let me start out by saying I have spoken with the sponsor, who is more than willing to sit with me and discuss my concerns and try to alleviate those. We have concerns about the 3-month provision. I frequently have participated in signing separation agreements 6 months to a year in some cases, not generally for any hourly employees, but certainly for some management employees. And the valuable consideration can be wages, can be lump sum payments, can be early retirement benefits, could be a combination of lots of things. I know one of the cases the Supreme Court looked at was the question of a lifetime restriction. Sounds unreasonable. Sounds unreasonable unless it happens to be someone that you're giving a very big retirement program for the rest of their life, and you're going to pay them until their death. That's another matter. So I think as indicated, case-by-case analysis is what's important here. We're not opposed to the codification of the Supreme Court's ruling. We're living under that now. We have just the concerns about the 3-month language, which I'll discuss with the sponsor, and some concerns, and it depends on how you read this bill, about whether or not we're criminalizing what generally has been a civil matter, whether there's a civil dispute. That does concern us a little bit, but I will talk to the sponsor about it. Thank you.
Thank you very much. Next.
Thank you, Madam Chair. For the record, Bill Welch with the Nevada Hospital Association. I, too, have spoken with the sponsor of the bill and look forward to working with him on the issues that we have concerns with. The hospital industry has a challenge in recruiting a lot of the high-level professionals that we need in our workplace, both in the management as well as in the clinical side. We spend a lot of money recruiting individuals from out of state into Nevada. We also spend money on relocation of those that workforce coming to Nevada, and many times we assist them in setting up their trade when they come to Nevada. And so our biggest concerns are with the 3-month piece. Again, we've spoken with the sponsor about that, and we look forward to working with him. He's indicated his willingness when I met with him, as well as today in his testimony. So we look forward to working with him on this legislation. We certainly do understand the intent that he's trying to make and appreciate that. We just need to try to figure out how we can balance it so that we can continue to bring in the level of professionals that we're recruiting. Thank you.
Thank you, gentlemen. And I appreciate you being specific exactly what the issue is for each one of you. That helps the bill sponsor to identify a possible discussion. So then anybody else in opposition then to AB 149 here in Carson City? Seeing none, then we'll move to neutral. That means you just want to provide some information. Okay, seeing none in Las Vegas or Carson City. Mr. Carrillo, do you have any last comments?
For the record, Assemblyman Richard Carrillo. Madam Chair, thank you again for allowing me to present the bill today, and committee members, thanks for the questions. And of course, again, what I'm looking for is to protect hardworking families of Nevada. So thank you.
Thank you, Assemblyman. Okay, with that, we're going to close the hearing on AB 149. We're going to invite the Labor Commissioner. We have a presentation on the State Apprenticeship Council, how it works, what's the function, what is the mission, how does it serve Nevada, is there any way to make it more efficient? And so, welcome.
Chairwoman Bustamante Adams, Madam Chair, members of the committee, thank you very much for the invitation to present here today. And I apologize for my voice a little bit. I've been testifying a little bit, so I do apologize. But again, thank you for the opportunity. I'm here today to present an overview of the State Apprenticeship Council. For the record, my name is Shannon Chambers, Labor Commissioner, Office of the Labor Commissioner, Department of Business and Industry. To my right here is Jennifer Jenkins, an auditor from our staff who is going to help me with the PowerPoint presentation. Should you have any questions as I go along, please feel free to stop me. And again, if there's any topic in the presentation that you'd like to meet with me further on, I'm more than happy to do that. So I'm going to kind of give a high-level overview here and kind of where we're at with the council and some options of where the committee and perhaps this body may choose to go with the council. So the council was created back in 1939, so it's been around a long time, way longer before I came into this world. But essentially, the council came into creation because in 1937 there was an act called the Fitzgerald Act that was passed by the federal government. It was also referred to as the National Apprenticeship Act, which kind of established standards and requirements for apprenticeship programs throughout the states. So in 1939, the State Apprenticeship Council, and I'll refer to it as the SAC, is how we refer to it in our office, was formed. Currently, the State Apprenticeship Council, the composition of the council is governed by Nevada Revised Statute Section 610.030. So currently you have 3 members from employer associations, 3 members from employee associations, 1 member of the general public, and then the state official designated by the State Board for Career and Technical Education as an ex officio member, but may not vote. So essentially you have a 7-member committee. The Labor Commissioner does serve as the state director of apprenticeship, but again cannot vote on matters before the council. The composition of the council in many respects mirrors what the federal government requires, and you can see it's section 29 of the Code of Federal Regulations, part 29.13. So the minimum requirements, even at the federal level, is you have to have essentially 3 members from employer organizations, 3 members from employee organizations, And then after that, the federal government kind of leaves it a little bit open in terms of how you compose your council. So again, the council consists currently of 7 members. So I'll then skip ahead to the purpose of the State Apprenticeship Council, and I won't read this word for word because you do have the slide in front of you. But essentially, it's to promote opportunities in apprenticeship, regardless of age, creed, color, sex, all the things that typically fall under equal employment, and it's to provide those opportunities in apprenticeship. It's also to establish standards for apprenticeship programs so that somebody, if they're going to be a state-approved program, has to go through some level of state requirements and meet those requirements in order to be called a state apprenticeship program in Nevada. So currently, as I said, we have 7 members on the council. Myself as the state director of apprenticeship, we do have a vacancy that occurred within the past 2 weeks on the employee side that we're going to be looking to fill within the next couple weeks. We are a 100% general fund, the council and the labor commissioner's office. We are a bare bones general fund agency. Typically, in terms of the council, the only funding that we really receive are the wages for the council members, some printing, some paper for the special certificates that we give to the apprentices when they complete their program. So typically, it has never been an entity that has received great deals of state funding, and quite frankly, it has never received any real grant funding from the federal government. So I'll move ahead now to essentially the general powers of the State Apprenticeship Council. So the real powers of the council are to advise and guide the state director of apprenticeship on apprenticeship in the state. They advise the state director on programs that they feel should be approved. They advise the state director on programs that they feel should not be approved or that should be canceled. They may also advise the state director to the extent that there are complaints filed against an apprenticeship program. Once an investigation is concluded, the council could advise the state director to take certain actions against an apprenticeship program. But essentially, their role is to advise and guide the state director of apprenticeship. So I'll move to the next slide, kind of to give you a big national picture. So in terms of apprenticeship nationally, on the map that you're looking at, states can either belong to what they call the broader federal program, which means you essentially comply with federal law, and as long as you comply with federal law, then you essentially, as long as you meet those standards, can run an apprenticeship program according to federal law. These states in purple are states that have chosen to have their own state apprenticeship agencies. And the total number of states that have chosen to do that is 26. So on that map, you can see that Nevada is one of the 26 states who has chosen to operate what's called a state apprenticeship agency, also referred to as a SAA. So now turning to the next slide, and one of the main reasons that I'm here today is in 2008 and then again in 2010, the federal government, by regulation through the Federal Office of Apprenticeship through the Department of Labor, said, okay, SAAs, state apprenticeship agencies, we are completely fine with you having a council. But we need you to clarify in your law and in your regulations if your council is going to be an advisory council or if it's going to be a regulatory council. So in 2010, the commissioner at the time sent a letter to the Federal Department of Labor and asked for continued recognition as a state apprenticeship agency for the state of Nevada, pending completion of the required changes to either make the council truly advisory or to make it truly regulatory. One of the main issues to remember within that discussion is whether it's regulatory or whether it's advisory, you still have to have a state apprenticeship director or a state apprenticeship agency who is ultimately responsible for the decision to approve apprenticeship programs, to cancel, to make changes to the standards. no matter how you place that role of the council, the ultimate responsibility lies with the state apprenticeship agency. And this letter and this slide is the exact language from the federal government on that. Go back a couple, Jennifer, sorry. Okay. So that's the slide. That's the exact language from the federal government in the exact letter. Another key component of the state apprenticeship agency's role is they said that within their new regulations is that your state apprenticeship agency has to have a direct tie-in to an economic development. It has to work with, whether it's the colleges, whether it's now we know them as the Governor's Office of Economic Development, with Department of Employment Training and Rehabilitation, there has to be a tie-in to those entities. Now, as the council currently stands, and for those of you who know me, I will be very honest, I'm not sure that there is an active tie-in to those entities with the council right now, just based on the makeup of the council. We don't have members from Governor's Office of Economic Development. We don't have members from the universities. We don't have outside employment organizations on that council. So this is one area. And again, how that shakes out in terms of what this body decides and where the council goes and what it looks like, this is one area where we have not made changes to meet that mandate. Okay. So again, going back to advisory versus a
Ms.
regulatory.
Chambers,
Yes,
we're
sorry.
going to pause there for a second. We have a question. Ms. Carlton?
Thank you.
Sure.
And I know there are some programs in the state that actually coordinate with the community colleges. And they share staff, they share time. There's one very close to my district where when the folks leave the apprenticeship, they actually have an associate's degree. So it's a very close relationship. Those relationships don't count. I mean, we can document them, we can show how many folks, we can show the money going from the apprenticeship to the community college, or from the state to the community college to the apprenticeship, and the billings back and forth and how they share space and staff. That's not a good enough linkage to show that?
And Madam Chairman, through you to Assemblywoman Carlton, I think the issue that the federal government could raise with that is there's no link to the council. That certainly, those tie-ins are certainly valid, but there's no representative on the council that really is from, say, the community colleges or from the universities that represents those tie-ins that you're describing.
So the work doesn't count, just having somebody sit on the council would make a difference.
And again, Madam Chairman, through you to Assemblywoman Carlton, I don't want to say that. My understanding in my communications that I've had with the federal government about this issue is they want members on the council who actually represent economic development agencies. I certainly would never say that that work doesn't count.
Well, it doesn't count towards the credit that the box you need to check off.
Correct.
That's what I meant. Because we can't check a box.
Correct.
Okay, thank you.
Thank you, Ms. Chambers. Go ahead. And you can go directly to the members. You don't have to go through me.
Thank you. Thank you. So again, just looking at the slide describing what an advisory versus a regulatory council is. So an advisory council is truly that you are advising the state director of apprenticeship. A regulatory council means that the council could actually promulgate regulations at the direction of the state apprenticeship director. So those are kind of the two options that the federal government has lined out for state apprenticeship councils. So when all these changes came forward from the federal government, again, as I said, in 2010, the commissioner at the time asked for continued recognition in order to make the required changes in order to bring the state apprenticeship agency in Nevada into compliance with federal law. So in 2013, Assembly Bill 36 was introduced in an attempt to bring the state of Nevada into compliance with the new federal requirements. That particular bill did not pass. It made it out of the Assembly and pretty much went nowhere in the Senate. I was not the commissioner at the time, so I don't know exactly why it stalled, but needless to say, it didn't pass. So in 2014, the Sunset Subcommittee asked for a review of the State Apprenticeship Council and further justification of why the council should exist and what role it played in terms of apprenticeship and why it should continue. A report was filed with the Sunset Subcommittee identifying the unique nature of the council and the role that it plays in terms of apprenticeship within Nevada, and asked again for continued time to bring the state into compliance with the new federal requirements. So essentially now we are in 2017, and there is a proposal to move the State Apprenticeship Council out of the Office of the Labor Commissioner and into the Governor's Office of Workforce Innovation. So putting that issue aside, there's still the issue of federal compliance. We are still not in full 100% compliance with the new federal regulations. So the options essentially set forth are, we can go back into NRS 610 and make the required changes and clarify that the council is truly an advisory council, and submit that to the federal government upon passage, at which time they evaluate the changes and say you've met compliance or these are the areas that you still need to fix. The other option would be to go into NRS Section 610 again and create a true regulatory council through express language in 610, and again make the other conforming changes, bring that back to the federal government and see if they agree that, yes, that meets exactly what they want as far as compliance. The other option is to amend Nevada Revised Statute Section 610 to create either an advisory or a regulatory committee, one or the other, but keep the stricter standards that Nevada has in terms of apprenticeships. So, for example, in Nevada, apprentices have appeal rights. They do not have that under the federal government. There is also a requirement for a construction minimum wage in Nevada, which the federal government does not have a requirement for. There are also some additional requirements as far as granting of credit, denials of applications, ratios, and standards of qualifications. So to keep those additional stricter standards, we could keep those and ask the federal government that these are why we have these stricter standards and these are why we need them. And again, they would have to sign off on that as meaningful compliance. The other option is to make no changes and keep things as is. The risk of that is, to the extent that there's federal funding out there, that subjects the state to the risk of not being able to get federal funding because you haven't met federal requirements. I will tell you that in the past that has never been an issue because, again, the Apprenticeship Council never received any money from the federal government as far as apprenticeship. It is an issue now because there are apprenticeship grants that were given to the states in 2015 and 2016 through the previous presidential administration, and it is the opinion, I believe, of the Federal Department of Labor that Nevada needs to be in compliance in order to continue to receive those grants. So those are kind of the options available to this body. So on the next slide, just in terms of the 26 states that I referenced before, there are only 8 states that have actually reached full compliance with the new regulations. I've listed the states that have reached full compliance. As you can see, all but one of them are advisory. The only regulatory is the state of Washington. I will also tell you that, for some of these states, Wisconsin has always been referenced as a very strong state in terms of apprenticeship. South Carolina is another one. South Carolina actually doesn't have a state apprenticeship agency, but for example, Wisconsin, just in 2016 alone, and their appropriation for their apprenticeship program was $500,000. South Carolina, it was $2 million. So Nevada, we have traditionally been operating in the empty on this particular subject. So next I'll just kind of move forward to, and again won't get into the weeds, but essentially apprenticeship program approval is subject to Nevada Revised Statute Section 610.144. Our office does provide assistance to apprenticeship programs who are seeking to start a new program. We have a checklist and all the items that are listed there today. We help programs with those to try and develop standards and programs. And it's like any new program and any new venture, there's times when standards are brought before the council and they need changes and they need revisions. Most of the time, we're always able to work through those and get programs approved that meet the standards and requirements. A key point to remember, again, in terms of funding, and now we're talking about state funding, is in order on a prevailing wage job or a public work job, in order to be exempt from the prevailing wage, the apprenticeship program has to be approved by the state. It has to be a state-approved program, and the apprentice has to be registered in a state program. It's state money, so the state has to approve that program, and that's set forth in Nevada Revised Statute 338.080. Next, I'm just going to provide you with some general information on apprenticeship programs in Nevada. Currently, there's 81 approved programs, 77 state, 4 federal, 2,833 active apprentices, and that was for the calendar year 2016. The latest research we've done is we're now above 3,000 starting in 2017. Part of the reason for that is just the slow pickup in the economy and building and things like that again. And I'm happy to provide further detail on those programs to the committee as needed. Some additional information I wanted to share is I have received some questions about veterans, how many veterans are registered in apprenticeship programs in Nevada. Currently, there's 321 registered veteran apprentices in Nevada. Of the 81 programs, 45 programs have a method for direct entry to veterans. So again, that's probably an area that maybe could be expanded in terms of the veteran population. Again, our office would be happy to provide additional information on different categories outside the veteran category. I can tell you just the data, how we have to get it from the federal government in our system. It's not a system that just lumps, for example, minorities all into one group. There's individual groups for male, female, all different categories. So again, I'm happy to provide that information to the committee as requested. Again, turning to the next slide, as far as general information for those seeking apprentice, on our website, we have a whole list of frequently asked questions that we provide for persons seeking to enter into an apprenticeship program, and we're always happy to meet and discuss the requirements, and we try and conduct as much outreach as we can. Every November, there's National Apprenticeship Week, and we do work with the Federal Department of Labor to conduct some outreach during that week. But essentially, that is a high-level overview of the council, and again, explaining kind of the compliance issue and where we're at and the options that are available to this body. So again, thank you, and I'm happy to take any questions.
Thank you, Ms. Chambers. Ms. Neal, do you have a question? Okay, I'm going to give you time to think about it. Mr. Daly.
Thank you, Madam Chair, and probably have several questions and some comments. And I'll start with before we had the big downturn in various things, any idea how many apprentices were registered in the state before that? You may not know. I don't know if you looked it up in preparation for this or not.
Again, Madam Chair, to Mr. Daly, Assemblyman Daly, my understanding is we were over 4,000.
So we're building back up. And I am quite familiar with this subject, as you know. Worked on AB 36 in 2013 and various things, and understand the government. You know, and maybe I don't agree with Ronald Reagan too much, but you know, we're from the government. We're from the government. We're here to help. It may not be the words we want to hear in this particular case from the feds. In Nevada, we have the higher standards and various things. Nothing in the federal law prohibits us from having those higher standards, does it?
Again, Madam Chair, to Assemblyman Daly, no, nothing prohibits the states from having higher standards, right. Not to my knowledge.
And I know recently, you know, from my regular day job nationally, there were a lot of those states that have the federal programs and various things, and programs that got approved
through them. And then when they went back and checked on the performance of those programs, how many apprentices did they actually graduate? What were the classes that they provided? They had dismal graduation rates and performance. In fact, many of those programs ended up being decertified because they were really just a sham to pay low wages. We have not seen that in the state of Nevada with our process, whether you want to call our State Apprenticeship Council advisory or regulatory. I think they've acted more as regulatory than advisory, but essentially they have a high level of standards. People have to meet the requirements in 2929 and 2930 plus 610 and NAC 610. Do you know of any programs that have just been shell programs, not graduated apprentices, not really providing the curriculum and the various things that, in other words, our programs under our system have performed pretty well. So would that be a fair statement?
Again, Madam Chair, to Assemblyman Daley, I think that is a fair statement. I went back and pulled data in terms of complaints against apprenticeship programs in the state of Nevada, and I'll just go through just the past year. So we had, actually past year, we had 9 complaints, but they were against one particular program. And I'm not going to name the program, and I'm happy to name it to any committee member that requests it. We investigated all 9 of those. We found no violations. Prior to that, the 5 years prior to that, we had 2 complaints against apprenticeship programs. Again, those complaints were found to be not valid. It was somebody who took the test to try to get into a program and didn't pass and filed a complaint. But we typically, and again, I've been in this position about going on 2 years, we don't see rogue apprenticeship agencies out there in the state of Nevada.
Then the last one, Mr. Daley, and then I'll let somebody else ask a question.
Very, very good. Thank you, Madam Chair. And maybe you can come back if I have another one. But so the last thing, I guess, it's the only last one I get for now. When we were trying to do AB 36 and trying to meet all of the steps that the government wanted us to do in order to be recognized, and there are benefits to that if we're recognized by the feds, and not to mention the grants and various things, but apprentices would have reciprocity across state lines and various things. Before we changed or proposed to change anything that's in our current statute, that was conditioned upon the federal government recognizing us. And I think I would hope that we would take that type of approach again. In other words, we'll try, but if the mountain gets too steep or they ask too many things or they're going to change what we believe has been a success in this state, I believe has been a success in this state, to try to say somebody in Washington knows better, I think we would need to have those, and I know you're not in charge of the bill, but is that, do you think, a sound approach as well? We don't change our state laws until we know they're going to recognize us. We'll make an attempt, but if they put the bar too high, I guess we don't need them.
And again, Madam Chair, with through you to Mr. Daley, again, I think there's choices before this body. I also work for an administration that I believe feels that continued recognition as a state apprenticeship agency is critical in terms of not only expanding apprenticeship, but in terms of workforce development. I would point out that on the federal level, there is going to be a change. There's going to be a new Secretary of Labor. I don't know what direction this is all going to go. Barring my legislative schedule, I'm supposed to attend a chair and directors meeting at the Federal Department of Labor, where hopefully they're going to give us more direction. I quite honestly, 2 months from now, I don't know where this is all going to go. And that's my best answer.
Thank you. Mr. Brooks.
Thank you. So we're currently not in compliance with the federal regulations, and is there some sort of a deadline or a benchmark where if we don't get into compliance, then those dollars that are either available or we're currently getting will go away? And could you give me kind of an understanding of what those dollars actually are? Like, what does that represent?
Again, Madam Chair, to Assemblyman Brooks, in terms of a benchmark, as you can see from the one map I showed, there's only 8 states that have actually come into compliance. I have never been given a directive as the state apprenticeship director that said, if you're not in compliance by this date, you're out. So that's my best answer on that. I don't know, again, if a new Secretary of Labor comes in and says, you know, you have, 24 states or 20 states that are not in compliance, they have to get in compliance by 2019. That could come down any day. In terms of the federal grant funds, those funds went to the Department of Employment Training and Rehabilitation, and I believe some went to the community colleges. My understanding is that $700,000 to upwards of $1 million. Our office did not receive those grant funds, so I don't know the exact amounts. Mm-hmm.
And Mrs. Chambers, can you help me understand that? Because if the federal money went to Dieter, but when I asked the trades if they knew about the apprenticeship money, they didn't have any knowledge of it. And so I think that may speak to the question of the fact, do we have the right people on the council to, because it might have not changed since 1939. I think you said it's been set up that way. And Ms. Carlton alluded to that. Do we have the right people? Because I was really concerned when the trades did not know about that money. And so that's just a statement. My question is, does it hurt our relationships, because a comment was made in the Ways Committee, does it hurt our relationships with the current relationships that the trades have with CSN or other entities to put on the programs? Is becoming an advisory or a regulatory, does it hurt those relationships at all?
And again, Madam Chairwoman, it's my opinion that it doesn't hurt those relationships. I think, unfortunately, there has been a disconnect in terms of where those grant funds went and perhaps the trades. But it's my opinion that everybody on some level should be working together. We're all working in the same direction. This is a rare opportunity where federal money came to the state for apprenticeship. I think there's room to grow not only new programs, but the existing programs. And again, our office, in terms of actually managing those grant funds, that's one of the reasons why it didn't come to our office. We don't have the staff to manage millions of dollars in grant funds on behalf of the council. So essentially, I did work with the Department of Employment Training and Rehabilitation on those applications for the grants. I think, again, it's an issue now of, okay, the grant funds are here. How are we all going to work together to utilize those grant funds, not only for the trades, but for the universities and the community college systems and some of the new industries that are out there.
Thank you for that. And then going back to who serves on the council right now, on page 3, it says we have to have 3 employee representatives and 3 employers. So could you tell me who those employers, who do they represent?
So if you look at the organizational chart, so Mr. Funstein is a private painting contractor. He runs a private painting business. Michelle Doherty is a employee of the Associated Builders and Contractors. And Nanette Quitt is a representative of Sierra Pacific Power Company. So those are the 3 employer representatives.
And then can you expand on the employee one?
So Mr. Canali is a representative of the Pipe Fitters Plumbers Union. Mr. Gauker, same thing as a union representative. And then the vacant was an employee representative as well.
Okay, thank you very much.
And sorry, the chair is the member of the public, Mr. Christensen.
Thank you. Any other questions for Ms. Chambers? Mrs. Neal.
I don't know if thanks, Madam Chair. I don't know if this was mentioned or not, but for AB 36 in 2013, what was the background information on why it didn't pass? And then there were no further efforts between then and now to try to move legislation to get into compliance.
And again, Madam Chair, Assemblyman Neal, Again, my understanding of why Assembly Bill 36 didn't pass is that I think at that time the body either didn't feel that the changes that were required were that urgent, or that the language simply wasn't enough to get that bill passed. Once it did not pass in 2015, a bill draft request was not brought before this body. I started at the end of December of 2014. The budgets were already built. I did not recommend submitting a bill draft request at that time to make the changes.
So, just a quick follow-up. So, the statute reads they're advisory, but in order to get into compliance, they need to be regulatory, correct? That's.
Again, Madam Chair, Assemblyman Neal, no. Essentially, this body could choose to make it either advisory or regulatory. There are additional changes that need to be made in terms of definitions to conform with federal definitions, but the choice really is this body could choose to make it either advisory or regulatory and then make those additional changes.
And I guess the thing that I'm not clear on, or that's confusing to me, is why would anybody choose to stay, I guess, in the abyss of I don't really know what I am, or because what are they now? If they're not advisory, if they're not regulatory, and neither one of those positions that are in the current state help them get grants or help them move from a silo, what are they?
And again, Madam Chair, to Assemblyman Neal, in my opinion, the council is a mix of both right now. By statute, it says they are to advise at council, but if you actually look at some of the meat that's on the statutes, the council probably does have more power than I think the Federal Department of Labor would view as an advisory council. So essentially, it's a point where the state needs to kind of decide either or. Either we're going to go full in on the regulatory and the stuff that's already there and come into compliance with the federal government, or we're going to go pure advisory.
Okay, and just final. So if the CFR has been in a particular state for like a really long time, then what are the chances of the CFR becoming what we are now, right? If we're a hybrid now and the CFR is saying you need to pick, I guess I'm not crystal clear on what's the reluctance. Have you said it? Did you say what it was? What's the reluctance to pick?
And again, Assemblyman Neal, I haven't said what the reluctance is. Again, there's interest on all sides of this issue. I think and again, I can't speak for the apprenticeship programs, but I think that there are those programs that feel that having a strong regulatory council ensures, to Mr. Daly's point, the quality of the programs, the safety of the apprentices. I think on the other side, there's a feeling that if you have an advisory council, things might be able to get done quicker because they're really advisory in nature. And to the best of my ability, that's really how I see the issue, and that's kind of where it's at.
Thank you for that. Any other questions? Okay. I just want to also hear and I don't want to put you on the spot, so don't feel that you have to come forth. But during Ways Committee, there were some trades that were had concerns about the Apprenticeship Council in moving to either advisory or regulatory picking one side. Is there anybody here from the trade councils that would like to make a comment on that? And don't feel, if you're not prepared, that's okay. I understand, and I might be putting you on the spot, so.
Thank you, Madam Chair. For the record, Todd Koch, President of the Building and Construction Trades Council of Northern Nevada. Our preference would clearly be to make the council completely regulatory.
We agree with the Labor Commissioner that currently it's a little bit confusing. There is some language that talks about it being advisory, but the council has also clearly acted as a regulatory council. So we would clearly have that as a preference. We think that that's the best way to protect the apprentices and the programs to maintain their integrity.
Thank you so much.
Thank you, Madam Chair. Nathan Ring on behalf of Labor's Local 872 and Operating Engineers Local 12. We're also in favor of making it clear in statute that the council is a regulatory body and not an advisory body. And for the same reasons, we're looking at safety, we're looking at higher standards so we can ensure that our state continues to maintain the highest quality of apprenticeship programs. Thank you.
Thank you so much. I appreciate you guys coming and giving your comment. Is there anybody in Las Vegas that would like to make a comment at this time? Mr. Christensen, I think yes.
Yes, ma'am. Thank you for allowing me to appear today. I did want to take a moment and just add to some of the comments that have been made, perhaps clarify a few things. I've been on the council for some time, and there were several questions asked. Assemblyman Daly asked what the maximum number of apprentices were at any point in time. I believe at one point we were up to 13 or 14,000. That was just on the precipice of the downturn in the economy. Some of the programs had as many as 1,000 apprentices themselves. And so I think it's directly related, the numbers today are directly related to what we've experienced primarily in the construction trades industries. There were some comments about federal compliance and whether anything had happened in an effort to try to dovetail our activities with the requirements of the Code of Federal Regulations. The answer is yes. We've held a series of workshops in which we took, I believe, at one point, 70 or 80 comments from the federal government, from the Department of Labor through the training entity. They've had different names through the years, but at any rate, in our workshops, I believe we agreed to conform on upwards of 60 of those requested changes. The items that you've heard discussed just briefly today about wanting to retain a regulatory nature, wanting to make sure we have safety ratios, hoping to preserve our construction industry prevailing wage, wanting to be able to preserve the apprentices' ability to appeal to the council if there's a wrong committed in a program. We want to make sure those higher standards are preserved, and the federal government simply does not have those kinds of requirements in their Code of Federal Regulations. Just two items to add additional information about the composition of the council. Mr. Funstein, who is one of the employee representatives, actually is the, I believe, director of the PDCA, which is the Painters and Decorators Committee, Contractors of America. That's a much larger group, not just a single private entity, and so he represents a variety of contractors in that role. Mr. Gauker, who was mentioned as a labor representative, had previously worked for the IBEW in their JATC program, was retired from that some years ago, and then went to CSN in capacity as a director of a correlator, a coordinator with the community colleges to try and make sure that classroom training and the ability to obtain credits from the curriculum offered through the community college was properly documented and done in an appropriate manner. So we have a lot of a lot of great experience on the council of people who dearly love it and want to preserve it. We've never had anything that you would consider a budget that is sufficient for the cause, and would welcome new money to try and flesh out and come into better conformity with the federal statutes. I would say about AB 36, we appeared before, I believe, this body. We also appeared before the Sunset Committee and testified that we wanted the federal government to come and show us what was wrong and what needed to be changed. We, in fact, invited them to all of these workshops that were held. They never appeared. We've had what we think to be pretty good working relationship with representatives of the federal government who come to our meetings on a quarterly basis, but have not participated one-on-one during these regulatory revision workshops. And we'd love to have more workshops. And I think you'll find that you'll have 60 or 70 of those regulatory comments again accepted by the council members, and we would recommend those as part of a new assembly bill or Senate bill to conform to the federal statutes. You'll find us to be, I think, very thoughtful in our approach. We believe in apprenticeship. We love what committed apprenticeship organizations mean to the state, because they very in fact build the network of qualified workers through a variety of the 80 or 90 organizations that are currently functioning. So we appreciate you taking time on this, and we will cooperate, but we do want to be regulatory. I would point the council or the assembly's attention to one particular statute. It is NRS 610.095. Those two sections 1 and 2 grant the council the right to register and approve standards of apprenticeship for different programs. Under subpart 2, for a good cause and after a hearing and opportunity to appeal to the labor commissioner, we can actually suspend and terminate and place a program on probation. And so the statute itself, under those two provisions, is clearly regulatory. The citation that was given to the assembly earlier are from the administrative code, which would be superseded by the statute. And we appreciate your time. Thank you today.
Thank you, Mr. Christensen. Okay, seeing no other questions for the Labor Commissioner. Oh, yes, Ms. Carlton.
Thank you, Madam Chair, and thank you, Mr. Christensen, for all your hard work. You've been doing this for a very long time. You have an excellent reputation. Every time I have a conversation with someone about apprenticeship, they always say to call you or talk to you because you are the person in the state that everyone respects on this issue. So I just want to thank you very much for all the hard work that you've put into this, helping hardworking Nevadans get good jobs through these apprenticeships. So thank you very much.
Thank you so much.
Okay, then we're going to go ahead and go into public comment if there's nothing else on the State Apprenticeship Council. Mr. Bacon, are you coming for the council? Okay.
Thank you, Madam Chair. For the record, Ray Bacon, Nevada Manufacturers Association. Let me stir in a little mud in the water just to confuse the issue a little bit. In the last year and a half or so, there has been a small group of manufacturers in Carson City that have been working with a small group of manufacturers in Germany to work on a joint apprenticeship program, which is funded almost exclusively by the employers, to work on an apprenticeship interchange operation in the machining field in the machinist type category. at this stage of the game, as you can take a look by the list on the back of the thing, almost all the apprenticeships in this state are focused on the building trades, and yet we do have other fields where apprenticeships do exist in other states. In the manufacturing sector, we were just too small to matter for decades, and now there's at least some interest in this thing. As you move forward on this thing, I have absolutely no idea how you integrate that different type of operation and different type of entity into what you're doing with the Apprenticeship Council, but it's probably something that at least should be pondered and considered. Karsten Heist, that most of you or some of you have at least met and things like that, was kind of the coordinator of pulling that program together. With Clickbond and Weinberg are the two manufacturing companies in this area that are working on it. There's some others that are interested as well in the whole thing. So this is not to say anti-council, pro-advisory, pro-regulatory, or anything else. It's just we got one more piece of mud in the water to stir the whole entities, and as to take a look as we're moving forward, we probably should consider that as to how do we make that inclusive somehow of making sure that those programs who do have considerable value are at least covered, or whether they're kept outside. I think right now they're working directly with the federal regs and not with state at this stage game, but I'm not sure on that. I probably should know, and I don't.
Thank you, Mr. Bacon. I think that you have bringing to light a very good point that it's beyond trades as well. So I appreciate that. Any other comments then? Okay, thank you, Ms. Chambers, for putting that information together. I know there was a lot of updates that needed to happen, so I appreciate your work. We're going to move into public comment then. Up in Las Vegas, is there anybody there for public comment? Seeing none here in Carson City. Okay, I just want to remind the committee on Wednesday we do have 2 bills up for work session. We'll be hearing 3 bills that day, but we also will have a subcommittee on energy after that, so your attendance is highly appreciated. We will do the work sessions at the beginning so that we can move into the bills afterwards. With that, we'll adjourn Commerce and Labor. Thank you.